Hello and welcome to Unacademy. Welcome to the Polity Project, a new series of 6 video lessons on Indian polity starting today. And every day at 8 p.m., one video lesson will be made public. Topic for today: procedure established by law, the due process of law. In Prelims 2023, this question was asked, which many students got wrong. In fact, some teachers who teach polity for the civil services examination also got this question wrong, which means for prelims, the focus should not only be on facts, the focus should be on conceptual clarity as well. And here on this YouTube channel, you will gain both facts as well as conceptual clarity. So, like this video, subscribe to our channel if you haven't yet, and let's get started. But first up, an important announcement which my team wants me to share with you. Should you wish to prepare with us for your civil services examination, and you wish to be taught by these teachers on the screen in English medium, then consider joining us, enrolling with us, subscribing to our UPSC courses, because right now, because of the Independence Day celebrations, Unacademy has slashed its subscription plans, and now 12 months of UPSC subscription is available at 17,999. Go to our website, check various price options, various plans, use this code IAS English, and automatically the lowest price will be displayed on your screen, and then you can learn with us. Let's get started and let's look at Article 21, which says no person, which means this fundamental right is available both for the citizens as well as the aliens, non-citizens. This is a fundamental right under Part 3 of the Constitution, Article 21. No person shall be deprived of his life or personal liberty, except according to the procedure established by law. This fundamental right makes it clear that your right to life and personal liberty is not absolute, which means your life, your personal liberty can be deprived, but only according to the procedure established by law, which we have borrowed from the Japanese constitution. But what is this procedure established by law? For that, we have to understand the 3 tests that the court will perform. For example, I was on the roadside, the police party came, arrested me. Matter went to the court. Now the court will ask the executive, the court will ask the police, under what law did you arrest this individual? Because is there a law which says that if you stand on a roadside, you will be arrested? Your right to life and personal liberty can be deprived? There isn't such a law, and I will be set free. Because law is necessary. There has to be a law under which you are to be arrested. Without a law, you cannot be arrested, which means it was an arbitrary arrest, and I will be set free. Now, what if there is a law? The law has to be a valid law as well. And what is this valid law? For that, we have to understand an important concept called legislative competence. What do we mean by this legislative competence? Listen to me carefully. There is something called Schedule 7 of the Constitution, which talks about distribution of legislative subjects into union list, state list, concurrent list. Who has the power to make a law on any item mentioned in the union list? Parliament. Who has the power to make a law on any item mentioned in the state list? State legislature, state legislative assembly, state legislative assembly plus state legislative council, where we have a bicameral legislature. But who has the power to make a law on any item mentioned in the concurrent list? Both parliament as well as state legislature. What if Karnataka legislature enacts a law and says whoever is in possession of banned 1,000 denomination notes, you will be arrested? I was found in possession of these banned 1,000 denomination notes. The police party came and arrested me. Is there a law which justifies with the person's liberty? Yes. Is this law valid? For that, we need to understand whether Karnataka legislature had the competence to enact such a law. Because in the distribution of powers, legislative subjects, state legislature can enact a law on any item mentioned in the state list, which means law and order, police, agriculture, gambling, so on and so forth. State legislature does not have the competence to enact a law on currency because currency is under the distribution of powers with the union. So parliament has the legislative competence to enact a law on currency. So although Karnataka legislature passed a law, there was a law, but this law was not valid, I will be set free because Karnataka legislature does not have the competence to pass such a law. Third, are the procedures laid down by the law strictly followed or not? Strictly followed in the sense, listen to me carefully. Offenses can be broadly categorized into two: cognizable offenses and non cognizable offenses. For example, a cognizable offense is one in which the police can investigate, the police can arrest without the warrant issued by the magistrate. A non cognizable offense is one in which the police can investigate and arrest somebody, but only after the warrant is issued by the magistrate. One such non cognizable offense is defamation. Can the police arrest me in a defamation law? Yes. How? If I do not reveal my name and the address, which is mentioned under Bharatiya Nagarik Suraksha Sanhita, something which replaced Criminal Procedure Code. If I reveal my name and address to the police, I will not be arrested under defamation law. Or if I do not reveal my name and the address or give my incorrect details about my name and the address, I can be arrested by the police, even under a non cognizable offense. But what if the police is investigating defamation case, but I have revealed my correct name and address? I have not given the incorrect details about my name and the address. Even then, I am arrested, which means the police has arrested me arbitrarily. When the matter reaches the court will set me free. Why? Because the procedure which is laid down in the law has not been strictly followed. Because if I revealed my name and address, I followed the law, why should I be arrested? Which means procedure established by law, which is followed in India under Article 21, borrowed from the Japanese Constitution, it prescribes a three test. Is there a law? Is the law valid? Are the procedures mentioned in the law strictly followed? If these three tests have been performed satisfactorily, I will be arrested. I can continue to be in detention. My right to life and personal liberty has been deprived. But if you notice this clearly, this procedure established by law protects you only against the arbitrary actions of the executive. The police, for example. If the police is arresting me without a legal backing, there is no law which I have violated, yet I am arrested, I will be set free by the courts. If the police has arrested me under an invalid law, I will be set free. For example, I am arrested by the police under Section 66A of the Information Technology Act. Although this is a law, but this law has been declared invalid. This section has been declared null and void by the Supreme Court in 2015 in a famous case known as Shreya Singhal v. Union of India. Which means although I am arrested under a law, but under an invalid section of this law, I will be set free. Or if the procedures have not been strictly followed as laid down in the law, I will be set free. But what if this law itself is unreasonable, unjust, if the procedures are unfair? Procedure established by law can protect me against the arbitrary actions of the executive, but not the arbitrary actions of the legislature. What if legislature passes a law and says if you are teaching polity for free on Unacademy YouTube channel, you are a criminal, and as such your right to life and personal liberty can be deprived. The police can arrest me even if the law is unjust, unreasonable. What if the procedure says that to investigate this particular crime, the police will be given 1,000 years to investigate? Such a long time makes it arbitrary. But if the police follows this, even if the law is unfair, unjust, unreasonable, the courts cannot come to your rescue. This is procedure established by law, which protects you against the arbitrary actions of the executive, but not the arbitrary actions of the legislature. The year was 1950. A.K. Gopalan v. State of Madras, 1950. Mr. Gopalan was a communist, and he was arrested multiple times from 1947, even after we became independent. Sometimes he would be arrested, the court will set him free, but then new charges will be applied, and this person would be arrested again. And he would primarily be arrested under preventive detention laws. Matter went to the court. But these preventive detention laws are made by legislature. Procedure established by law can protect you against the arbitrary actions of the executive, but not the arbitrary actions of the legislature. The court upheld the detention of A.K. Gopalan. Why? Because the law has been passed by the legislature. We follow procedure established by law. We can protect you against the arbitrary actions of the executive, but not the legislature. Then ADM Jabalpur versus Shivakant Shukla, 1976, also known as the habeas corpus case, one of the darkest moments in the history of Indian Supreme Court. Emergency was imposed in 1975. Srimati Indira Gandhi was the Prime Minister. And then a draconian law was passed called MISA, Maintenance of Internal Security Act. Thousands of politicians, trade union leaders, student activists were arrested. One such individual was Shivakant Shukla. And since we were in a period of emergency, the right to approach the court was also suspended, which means Article 32, its enforcement was suspended. Even if the arrest was illegal, arbitrary, you can't go to the court, because you can't approach the court under Article 32 when emergency is in place. 5 judges of the Supreme Court had to decide whether your right to approach the Supreme Court during emergency can be suspended or not, whether Article 21's enforcement can be suspended or not. 4 judges said yes, because the law has been duly passed by the legislature. We follow procedure established by law. And if the law says you can't approach the court when emergency is in place, we can't come to your rescue. The only judge who dissented was Justice Khanna. Why? Because we were following procedure established by law. But in United States, they don't follow procedure established by law. They follow due process of law. Which means in procedure established by law, if these 3 conditions are to be satisfied, is there a law? Is the law valid? Are the procedures mentioned in the law strictly followed or not? Not only these 3 tests, 4th test will be prescribed. And this 4th test says the law has to be a just law. The procedures laid down in the law have to be fair, reasonable as well. For example, the landmark case in United States, Lawrence v. Texas, 2003. Homosexuality, consensual adult sexual relationship, was declared illegal in Texas. It was considered sodomy. So was there a law which justifies violation of personal liberty of individuals? Yes. Is the law valid? Yes. Are the procedures followed? Yes. But when the matter reached the court went behind the intentions of the legislature. Your law has to be just. Your procedures have to be fair. This is not a just law, because to criminalize adult consensual sexual relationship can never be allowed in a democracy such as United States. So due process of law protects you not only against the arbitrary actions of the executive, but also the arbitrary actions of the legislature. If the legislature enacts a law which is unfair, unjust, unreasonable, the courts will come to your rescue. But what were we following in India? Procedure established by law, because that is what is explicitly mentioned under Article 21. But then 2 years later, this is 1976, 2 years later, in a landmark case, Maneka Gandhi v. Union of India, 1978, Supreme Court said, no, we don't follow procedure established by law, we follow due process of law. Although technically the court said, listen to me carefully, there's a golden triangle of Article 14, 19, and 21. Article 14, which talks about right to equality, it also talks about right against arbitrariness. For example, I want to apply for a passport or I want to renew my existing passport. If it is denied, the authorities have to tell me the reason. Why is it denied so that I can approach the court, so that I can challenge this order? But if you can't reveal why my passport was denied, which means your actions were arbitrary. That's what Maneka Gandhi contended before the court. My passport has been confiscated and I am not told why. I am not given reasons, which means you are violating Article 14. Article 19, which gives me the fundamental right, freedoms, for example, to practice any trade, any occupation, any profession, to move freely throughout the territory of India, to reside and settle anywhere within the territory of India. Maneka Gandhi contested before the court that you don't have to just follow procedure established by law. Your laws should also not be arbitrary under Article 14. It should not also violate the freedoms under Article 19. So this golden triad becomes important. Article 14, 19, and 21. And this is what is due process of law. Supreme Court said, we also follow principles of natural justice. Natural justice in the sense, nobody shall be sentenced without being heard. You have to hear both sides of the argument in the court. If there is a case before the court, on one side there is an argument, on the other side there is another argument by the defendant. You have to hear both sides and then come to a conclusion. For example, if the passport authorities have confiscated your passport, they're not renewing your passport, you will have to hear the other side as well. No person shall be the judge in his own case. If the passport authority has declined to issue a new passport to you, they cannot be the judge in their own case and said, you can file an appeal to us if you're not satisfied with our refusal. There has to be an appellate authority. An authority shall act bona fide, which means in good faith. Long story short, in procedure established by law, the court will have to prescribe 3 tests. If these 3 tests are satisfied, your right to life and personal liberty can be deprived. But the courts are helpless against the legislature. The courts can protect you against the arbitrary actions of the executive. But in due process of law, another layer is added, that of non-arbitrariness. The law has to be just law. The procedures have to be fair, reasonable as well. And we follow principles of natural justice as well. Universal principles, not explicitly mentioned in the Constitution, but something that we follow. The authorities will have to act. Authority, whether it is executive, whether it is legislature, you will have to act in good faith. Nobody shall be the judge in his own case, and the judge has to act impartially. And at the same time, you have to hear both sides of the story. No verdict can be given ex parte. Now, this question on your screen, Prelims 2023. In essence, what does due process of law mean? Does it mean the principles of natural justice, or the procedure established by law, or the fair application of law, or equality before law? You can eliminate D because equality before law is Article 14. You can eliminate B because procedure established by law is different from due process of law. Now the question is, fair application of law or the principles of natural justice? Fair application of law. If the law is passed by the legislature, procedures are mentioned in this law, laid down in this law, whether this law is fairly applied or not. Who applies this law? Executive. Procedure established by law protects you against the arbitrary actions of the executive. So if the executive is not applying this law fairly, you have a protection. But due process of law in the reality means principles of natural justice, the golden triad of Article 14, Article 19, Article 21. Principles of natural justice means due process of law in essence. If you like this video, do let me know in the comment section. Wait for tomorrow, 8 p.m. We will have another video released under this project called the Polity Project. Thank you for watching. Goodbye. Take care.